Thank everyone for joining us today and taking time out of your day to join us for the presentation on the return to in-person hearings as part of our Zoom Divorce for Clients and the Modern Lawyer series. My name is Shannon and I'm part of the Community Engagement and Events team at Russell Alexander Collaborative Family Lawyers. I'm going to start with about a bit of housekeeping and some introductions before I pass things over to our panelists to get started with the presentation. So as we are presenting virtually today, we do apologize in advance for any technical issues that may come up. I will be available throughout the presentation, just behind the scenes for any questions or tech issues if they do come up. So if you are having any challenges throughout the webinar, please contact me at shannon@russellalexander.com, or you can send a message to me through the Q&A and I'll do my best to help resolve the issue. So in this 1 hour presentation, Russell, Rick, and Jason will be sharing their insights on the following topics: the Zoom divorce hearing, presumption guidelines and their implications, judicial regions and different approaches, the importance of in-person hearings, the pros and cons of virtual hearings, planning for bumps in the road, Zoom divorce tips and tricks, CaseLines and the Divorce Act changes, and the court's return to normal. And our panelists will also be sharing their concluding comments following that. There will also be a Q&A segment at the end of the virtual event. So if you haven't already, please feel free to submit your questions via the Q&A box, and we'll do our best to get to your question during the presentation. And just a quick note that we've made it so that everyone remains anonymous to other attendees. So you'll notice that the chat function has been disabled, but as I mentioned, you can send it in anonymously through the Q&A box. So we also just ask that you keep in mind that the content of this webinar is to provide you with general information and should not be considered as legal advice. Another note that we will be providing the links to helpful resources mentioned throughout the event in a follow-up email tomorrow, so keep an eye out for that. And for those of you who are in the legal community, we would like to note that this program has been accredited by the Law Society of Ontario for 1 hour of professionalism content, so it can be used towards your CPD hours. So without further ado, it's now my pleasure to introduce Russell Alexander, Rick Peticca, and Jason Isenberg from Russell Alexander Collaborative Family Lawyers. So first off, we have Rick, who is an associate lawyer at our firm and brings over 14 years of family law experience. Rick focuses on all aspects of family and matrimonial law by supporting his clients in resolving matters. He fosters strong relationships with his clients that are built on trust and transparency. Rick collaboratively works with his clients in achieving effective solutions through various dispute resolution mechanisms, such as finalizing domestic contracts through negotiation, mediation, and collaborative law processes, or through the litigious process of court and arbitration. Jason is an associate lawyer at our firm with over 20 years of legal experience. Jason excels at helping his clients reach resolutions in their family law issues and finds it very rewarding being a family lawyer, as it gives him the opportunity to support people in moving forward to start the next chapter of their lives. Through his many years of experience, Jason has been praised for his hard work in providing a personal touch with his clients and has become known for his patience and attention. Russell is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 20 years of experience, Russell offers a wealth of knowledge and expertise in collaborative family law. He uses his experience with a client-focused approach by creating unique solutions for each of his clients to enable them and their families to move forward with their lives in a compassionate and collaborative manner. So now that you know a little bit more about our panelists and what we have on the agenda today, I'm going to pass things over to Russell.
Thank you for those kind words, Shannon. Please put your questions in. We've got some questions that were sent in advance, but we like to go answer questions throughout the program. So ask whatever you'd like to have us address. We have some polls. Please participate in the polls. It makes it a little bit more interactive. It gives us a sense of who our audience is. We can kind of tailor our discussion to our audience. Do we have a guarantee today, Shannon, or are you not offering that today?
I wouldn't disappoint with our guarantee. So as always, we offer our money back guarantee for our complimentary webinar. Right. But yes, please share your feedback following. In all seriousness, there will be a survey at the end of the presentation. So we always love to hear from our audience and your thoughts, and it really does help us grow the series.
And how can you go wrong? We're going to give you lots of show notes with all the practice directions that you need to be mindful of and a bunch of information that you'll find helpful. So let's run our first poll. And what is your reason for joining us today? So this will give us a sense of who the audience is. Please put your answer in there. We'll give everybody a minute to answer, going through separation, divorce, legal, professional, other professional, helping a friend or loved one. While we're waiting for the poll, waiting for everybody to vote, you've got a special offer, Shannon?
Yeah, so just going back to our survey at the end, we do have a fairly new book from Russell, The Zoom Divorce, which is very tied to our event today, of course. So we are offering a complimentary ebook for those who provide feedback from the survey and offer some suggestions for topics. So I'll remind everyone at the end, but that's a little something to look forward to.
A little teaser. All right. Let's see who our audience is today. What do we got? So 16% going through separation and divorce, 64% legal professional. Well, you're going to like what we talk about in terms of practice directions. Other professional, 12% want to learn more, 5%. Other, 3%, you can put that into the Q&A. So first out of the bat, the Zoom divorce hearing. Now we've gone through the pandemic for 2 years. Zoom divorce is like Skype. It's an electronic way to attend to your court hearing from the safety and privacy of your own office or your own home. In terms, and now we've got practice direction from the Chief Justice in April directing us, well, setting out presumptions, which we're going to talk about. Basically, they want to bring us back to court for certain types of hearings. It's going to be hybrid, so we're still going to have Zoom divorce in some fashion. Maybe not the fully remote system that we had previously, unless we go into another lockdown or we get another variant. And then we're going to be going back to these tools, and it's important to be mindful of certain things. I think a good tip is to run a mock Zoom hearing before you do your Zoom court hearing. You could do that with a clerk or a client, or just do it with a friend. Get familiar with the technology. You're going to need technology that has a video. You want your camera on. If you're counsel, you need to consider whether or not you're going to need an interpreter at your hearing and arrange for that in advance. Otherwise, your hearing is going to get adjourned. Be mindful of how the court's prepared to receive your documents, whether it's through CaseLines, which we're going to talk about today. Some judges require us to also email them the documents. Every court's different. They may require us to start filing documents for these hearings now as well. Each region has its own nuances, so you want to be mindful, okay, I'm going to this particular region, perhaps the Central East region. I know this case conference judge said I only want a 17F and a one-page summary. That's just one example of how varied the documents required for a Zoom hearing can be. Also be mindful of the breakout rooms. These can be very effective when you're having your Zoom hearing. The court registrar has the ability to set up breakout rooms so you can get that, in hallway feel or negotiation if you need to talk to counsel after receiving a recommendation, or maybe even just confirm your client's instructions and see if you can make a deal that day. You can go into a breakout room. Most courts are very accommodating. If you're able to come up with a consent, you return back before the judge and they'll give you an endorsement to reflect what you negotiated. Very effective way to use Zoom hearings. So that's just an introduction. We're going to get into this much deeper. So let's go to our second poll, and then we're going to get into some real nuts and bolts. So since April, have you or your client attended an in-person family court hearing? That could be a conference, a motion. The Presumptive Guidelines now set out for certain types of in-person hearings presumptively. Some judges in Brampton are taking it very strictly. Other judges, if you've been remote, they want you to continue remote. Other jurisdictions are saying, well, maybe September we'll start this up. So it'll be interesting to find out from our audience. Most of them are legal professionals. Have you been back to court since April for an in-person hearing? And your choices are, yes, it was a great experience. Yes, it was terrible. No, but I'm looking forward to it. I know a lot of colleagues love going to court, love bantering with their other lawyers, getting the gossip from the judges. That was a big part of the legal tradition prior to the pandemic. No, but I'm looking forward, or other, and you can share your comments through the Q&A. So let's see what our poll results are. So 13% said it was a great experience. 8% said it was terrible. No, but looking forward to it. 25%. I think there's a certain section of the bar that would agree with that. No, and I'm not looking forward to it. I think that's the majority answer at 45%. A lot of lawyers are concerned still with lingering health risks from the pandemic. They may have underlying health conditions, or their family may have underlying health conditions, or they just don't want to blow off 6 hours going to court when they can do it in 45 minutes or an hour from their office. And other 9%. So it'll be interesting to see what those other ones are. But let's go into the presumptive guidelines. So Jason, what are we talking about here when we're talking about presumptive guidelines?
Well, I mean, there are two levels of court in the province: Superior Court and the Ontario Court, Superior and Higher Court. I'm going to talk mostly about that. I mean, there's several modes of appearance. What we've got is virtual, and that's what we've kind of been doing since March of 2020. Everyone appears, in some form of virtual already. Some court dates will still continue that way, it would seem. There's the hybrid, which is some people will be in person, and some people will be virtual. That's available, and is something that I guess could be used in the future. That's something that is not what we've been doing since March 2020 and is a new thing. Then there's in person, which of course is something that we did before the pandemic, and from the polls people have already gone back to doing, and some jurisdictions have insisted that start already. Video conference or audio conference was something else they proposed. This is connecting to court by video or connecting to court by audio only. Again, that's something that and again, the teleconference they've proposed too. These are things that were available before the pandemic, so they're not new. They're things that we did already. Sometimes judges would say, let's just do a telephone call. And, there were people that couldn't make it in. They were out of country or out of province. So some of these modes and methods are not anything new. They're just something that we're going to possibly be reintroducing instead of the Zoom aspect of work.
Let's touch upon that. We're hearing, from judges, mixed lists are not doable, right? Well, we've had mixed lists for years prior to the pandemic. We would have a full court list in person. The judge would go in the chambers, either do a conference call or a Zoom call. I don't know, how is this all of a sudden not doable when we've been doing it successfully prior to the pandemic? What do you think?
I think it is. I mean, it's kind of funny. When I was doing some research for this, I was looking at practice directions from years ago, and one from 2015 where there was a pilot project that you could do virtual conferences in multiple locations in the province. And that was before the pandemic was even a thought in 2015. So, they were moving towards some court, not a lot, maybe 5 or 6 in the whole province, but go there, do your virtual appearance for any other court in that area, like Oshawa for Central East and, Belleville for East. So this was a concept before we ever had a pandemic. And and we'll talk about it later, but we talked about it already, access to justice, saying, don't have to drive here, drive there. Let's do it all virtually and make it work if we have to. And the pandemic just brought that to the fore, really.
But the flavor of the day from some judges is, it's not doable. Pre-pandemic, I would do 10 cases. Now with Zoom, I'm only doing 4 cases a day. It's creating a bottleneck. These are the arguments we're getting from the bench, but it seems a lot more efficient doing it electronically. That's been my experience. What's your take here, Rick?
I agree with you, Russ. It does appear to be more efficient, though, particularly when you're on a hearing, whether it's a motion or a conference, and you're booked for an hour, particularly if it's a short motion. The judges basically say, by the end of the hour, when the hour is up, look, I need to get on to my next case. And so it comes across that it is more efficient. So I'm not sure how unanimous that is across all judges that it's inefficient. I haven't found any data to suggest that, how many judges are saying that it's more efficient than the ones that are saying that it's not efficient.
There seems to be a longing for the days of open lists, right? You'd have 20 motions set for 9:30. I'll do the consent matters first. The rest of you go in the hallway and work it out, right? And come see me in the afternoon. That seems to be a bygone era, right? That's not a way to distribute or administer justice, because these clients run out of money after 2 of these hearings that last 7 hours and it's adjourned. I think the client's money goes a lot further if they know the hearing's 1 hour. They can keep counsel involved throughout the case or even to the end and improve access to justice. But it sounds like I'm getting on a soapbox here, so I'm going to be quiet and let Jason go on. Sorry about that, Jason.
We're taking some information for what I'm talking about later. But anyway, I think, further what you're saying there, efficiency or not, I've found that these virtual conferences, if they're less on, you might have to wait longer to get one. And I can understand that. And I think that's a problem. But when you get one, I found them to be extraordinarily more useful than having 7 or 8 on and a judge saying, I've got 15 minutes for you. What's the most important issue? And I'll talk about that one. When they've got 3 a day, they can focus on all 3. So I'm finding that I get better, what you're really looking for is judicial opinion that day. You're getting a better opinion. I'm getting more, more time with the judge. Making that conference useful instead of my client looking at me at the end of the 15-minute one and saying, what was that all about? Because it's stressful. You get prepared, you spend a lot of money, you're like hoping you get some resolution, some help that day. And if it's 15 minutes of judge's time and they're rushing you out of there, you don't feel like you got any value for what you did. And I feel that these virtual conferences was real value. At least they were at the start and still continued. Yes, you're waiting longer for them, but that was a problem in some jurisdictions even pre-COVID.
Yeah.
Moving on, these mode of appearance and whether or not be in person or not. Basically, we're looking at, I think, different ideas of what the court date's about and why the court said they should be in person or not. Really, it hinges on, I think, whether there's a settlement element to it or not, and whether there's a decision to be made or not. And the items where there's a settlement element, they're saying come in person. Come in person. I mean, even some local areas are saying, we normally do a court date where we're scheduling trial, but we still talk settlement. So we want you to come in person for that. Where other jurisdictions are like, no, it's mostly about setting the matter for trial. We don't need in person for that. So I think that element is there. I think the belief is that if everyone's in the same place at the same time, you catch lightning in a bottle. So if you're going to be coming in where settlements discussed, like the case conference, like the settlement conference, it's in person. So we have you all in the same place, and you can't leave until you get a settlement kind of idea, or you hope you get a settlement. But matters where there's not going to be a settlement element, virtual. Matters where you're going to make a decision, like a trial, like a long motion. The shorter motions, the 1 hours, they're saying, can be done virtually. But at the end of the day, I think if the judge is going to be possibly taking a lot of questions, asking a lot of questions, taking a lot of documents, like at a hearing, that's where they're saying, okay, let's do it all in person as opposed to virtual. So it seems to be that's, I think, where we hinge on whether it's in person or not. And, I think at the end of the day, that makes sense. I don't have the data, but maybe matters were settling less when they were being done virtually at the conference stage, settlement conference, case conference, and they were settling more when it was in person, and that's where they decided to draw the line.
All right. Thank you for that.
Well, the only thing I should add, Russ, sorry, yeah. I don't know. There are people that still say, despite this element of in person or not, there's a form that we're showing right now. You can make a request. You can say, I'd like to have my matter virtual, even though it's supposed to be in person. I'd like my matter in person, I guess it's supposed to be virtual. The form and looking at it, I've not had to fill one out. I know Rick has had to fill one out. I've not made this request yet, but it seemed to me that it has the information a judge requires to make this decision. the feeling I'm getting is that they're not going to change their mind about this. You really need to give them a compelling reason to move an in-person matter to virtual, as an example. And I think what they're really looking for is why that proposed method, that virtual versus in-person or in-person versus virtual, is necessary in the interest of justice. Interpret that any way you want to. That's what we're looking at the greater good, the bigger idea, the bigger picture. Why is this necessary to be done this way or that way? I would also recommend, I haven't filled the form up, but from what I'm seeing, discuss this with the other side first. See if they consent, see if they oppose. That's going to be relevant to that judge if they do. So when looking at this form, it's a good tool. It's brief, it's 1 page. But at the end of the day, there's some information there to fill in, and you don't fill it in with a compelling reason. I think you're wasting your time. That's what it sounds like.
We'll let Rick talk about the form in a sec. Sorry, but it's almost a hardship kind of argument. If it's an inconvenient drive or expense, it's not enough. I've seen cases where counsel have consented and they've said no. One case, counsel had COVID, and they said no. They adjourned it for 2 weeks. They could come back in person. Other regions, they want it to be remote. If you're started your case remotely, you're going to continue remotely. And so I think depending where you are in the province, you're probably not going to go back in person until 2023 at the earliest, maybe even later than that. But Rick, this is a really good resource you've added. Tell us about your form.
Well, this is a form that actually was presented to me by another lawyer who, on one of my cases, who lives 4 to 6 hours north. The case is in Tri-County, and it's for the first case conference.
So Tri-County, that's the Central East region, right?
That's correct. And effectively, their argument is, look, with gas at over $2 a liter, and this is the first case conference, and much of it they probably foresee is going to be disclosure-related issues. Can we have a virtual case conference? It's just the expense of traveling back and forth. I mean, just the travel alone, they said it was probably about 3 to 4 hours one way, and that's going to add up. And I think that's going to be a problem for their clients. So, it's the access to justice issue is really financial, and it's financial in its roots. And this is a prime example of when you're going to a first case conference. It's not settlement ready, and it's really primarily about disclosure. And the other side is saying, look, my client only earns X amount of dollars. It would really help them to further their case and their interest of justice, of what they consider justice, for the attendance to be virtual.
Yeah, go ahead, Jason.
I was going to say the judge would probably say, then don't make your case conference about disclosure. Get that ahead of time, which works sometimes when you've got cooperation. Doesn't work other times. But they would say you can remedy that. Is planning will always remedy those problems, right? Is what they're going to say, and that's not a compelling reason. They want the case conference to be more useful, so they would tell you, just bring a 14B motion for disclosure well in advance of your conference if you can't get cooperation.
I think Rick's touching upon a bigger issue here. I think there's a disconnect with some judges and the public in terms of access to justice. This inflation is a serious problem, and we might be heading for a really significant recession and possibly stagflation that we haven't seen in 40 years. Some people, paying an extra $100 for gas that particular week means other things are going to have to get cut, right? Their groceries or heating or what. This is a real problem for many families in Ontario. And if we look at that quote we started off with, say, oh, well, hire a local lawyer. Some people don't want to hire a local lawyer, right? They want to bring in somebody from out of town or somebody they feel who's going to be more independent. So, I think you've really touched upon something here. And we're seeing cases where the form's filled out, it's on consent, and they're still ordered to go back in person. It almost seems punitive at that point. What do you think, Rick?
I agree. I mean, we have yet to receive the response on the case that I'm referring to. from the court as to whether a request from the other lawyer is going to be accepted. But in a way, I can relate, because when I can understand where the other side is coming. It is quite a drive for their client in this case here, given their income level and the cost. And even to Jason's point about planning ahead, even if it's just a disclosure issue, but just if you have the disclosure and you just want a judicial opinion at the first case conference, I think that lawyer would argue that you can get that at a virtual. You don't need to necessarily be there in person, face to face with the judge. The case is not ready to be settled. You can still get the judicial opinion on how to move forward on the next steps, even if you have the disclosure in hand.
I think we're going to see more and more counsel using these presumptions as strategic decisions, right? I know this person has a lawyer out of town. I'm going to say no to consenting to remote for a simple motion. Require, somebody from, say, Oshawa or Peterborough to drive to Windsor for a 45-minute motion and back. They're strategically trying to cause the other party to go self-rep, which I think is improper, right? I think there should be more flexibility, especially given that some of these communities you can't readily access counsel. And maybe I'm wrong. I don't know. What's your take on that, Jason?
I agree with what you're saying, but I think that, that there's a reason why the Chief Justice gave this direction. This is what we're supposed to do. And you're a judge, and that's kind of like your boss, and you're a boss over all of us, but you're going to follow what your boss says, which is this stuff's in person. And unless there's a good reason, they've probably got an idea of what they're expecting. I don't know how much freedom they get to say, yeah, fine, I'll change it, or if they've been given pretty clear instructions. I mean, every court is allowed to set its own rules, more or less, about this. We'll talk about that later. But again, I think, you've been given a direction. What do you do? All these things are compelling, but they're focused on their agenda, and we're focused on a different one.
Right. Well, that's a good lead into our next slide. So we had our summer law students, Joseph and Shanza, do some research for this. So I'll take responsibility if it's not correct, but it looked pretty accurate to me. So let's take a look at the regions and what counsel and the public need to consider. So the province of Ontario is a fairly large area, so judicial regions and different approaches. So these are all the regions we have, and we've broken it down further in the next slide. So when considering what your presumptive mode is in relation to Zoom divorce, we have 38 regional directions and 3 province-wide directions. And here's the breakdown. There's 8 regions. Here's the breakdown for each region. Within regions, there's different directions for different courthouses. So within one region, I saw that they were taking the first case conference and saying all first case conferences are remote. I think that's a great idea, right? You're getting introduced to the judge. You're probably talking about disclosure issues. You might be getting some recommendations that need to marinate for a few days. Nobody's usually ready to make a decision at the first case conference. Some of them are, right? Maybe 10%, but not all of them. So that particular region said first case conferences are remote. That local practice direction said remote. Within the same region, first case conference is in person, right? So now we're getting different treatment for different clients and different lawyers within regions and across the province. And even being legally trained, it takes a bit of work to find out the correct practice direction for whatever courthouse you're going to be going to. But if you're a self-rep, this is nearly impossible to figure out or understand whether or not you're following the proper practice direction. So you need to be mindful of that. Check your local practice directions. I'm not going to spend much more time on this because we've got a lot more to talk about. But we're going to include all the practice directions as part of our show notes today. So we'll save you the time of having to hunt them down. We've got them listed by within the 8 regions and their sub-regions and the 3 provincial-wide practice directions will be made available to you. Having said all that, there's still some importance to, let's come back to this quote. We talked about this let's get our quote on the screen here. We talked about this in our opening water cooler sessions. So this is a note a Superior Court justice wrote to their local practice hearing saying, be prepared to incur the cost of having counsel attend to that region, and if you don't like it, just hire one of the local lawyers. That's the mindset we're seeing from some judges, so want to be mindful of that. We'll circle back to this at the end if we have time, but it certainly gives us a flavor of how some courts are approaching it. Having said all that, in-person hearings are important, right, Rick? So,
well, you're right. You're right. Thanks, Russ. Look, in-person hearings were effectively the predominant method pre-pandemic, and really the hallmark of our court system. So, some people prefer in-person hearings, and I guess to Jason's point, I mean, if there's a question of whether there's a settlement aspect of it or if there's a hearing, it may be more effective in that sense. In the context of a hearing, in-person hearings offer more of a natural feel with body language, facial expression, more of the nuanced communication, as they would say. And some people have criticized the use of virtual hearings, saying that it takes away from that. Arguably, I don't want to look at finding more information that if there's a hearing and someone's wearing a COVID mask during the hearing, how that will affect the judge's ability to read facial expression in that sense. You're in a trial and someone's wearing their COVID mask and they're on the stand giving evidence. How's a judge going to assess facial expression in that context? And I think that's a consideration about this whole key thing of in-person hearings.
Our audience said they had been back to court since April for in-person hearings. So if you can put into the Q&A box whether you were required to be masked or if there were masks or if there were no masks, what your experience has been like. I know when I Zoom into court and the judge is in court, he or she usually has the mask on, as does the registrar. So put in the Q&A what your experience has been. So, this idea of assessing credibility might be more difficult, I guess, Rick, if you have a mask on or if you're covered in some fashion.
Well, and I think that goes to the point of the importance of in-person hearings, is that when you're balancing this whole new reality of Zoom and post-pandemic and the arguments for virtual and the arguments against it, one of the strongest arguments that people have said about going back to in-person hearings is for that reason, is that it makes reading body language a little bit easier. But to the point that we were just discussed, if they're wearing a COVID mask, how is that going to affect credibility? It's an interesting point.
Yeah. Or if they got the plexiglass barriers up and it's giving a bit of a reflection, and I guess these are just learning curves that we're going to go through, I guess. So thank you for that, Rick. We haven't done a poll for a while. Let's run a poll. Are remote or Zoom court hearings more efficient? And we've got a variety of answers up there. While we're waiting for everybody to enter their results, I've got some questions that came in advance. So let's see if we can get through some of these. We're going to talk about CaseLines in a moment, but one question is CaseLine used by the lawyers or by the individuals or self-reps as well? Do you know if self-reps have access to CaseLines?
I can answer. I don't know if they have access, but they should. Part of its purpose is to share that information with everybody. So when I've had a matter that is occurring virtual, I've given my client access to CaseLines. I've done some trials where we've had it virtually, and I've wanted my client to have access to CaseLines so they can see a document I want to show them as an exhibit, for example. So I would think a self-rep should have access to it. I think if they're given that. They should be. Every party's given access.
Right. Thank you for that, Jason. Let's see our poll results. And as they're coming in, we've got some Q&A. Just leave this up for a moment, the poll results. So the issue of being masked in in-person hearings, our audience are sending in some comments. Judge was masked, some counsel were masked, and some clients were masked. Another one coming in from Guelph. The court did not require masks and nobody wore masks. There was no one else in the large courtroom with masks on. So it's kind of all over the map, right? If you got health problems, or if you're worried about catching COVID, you're going to be going into an environment with unmasked people that you don't know. You don't even know if they're vaccinated. I guess that's the way it is right now. All right. More efficient or less efficient? Are they more efficient? No. Not when there's issues of credibility to decide. 16%. Yes, always 18. It depends on access to technology. 24%. Saves time and expense. Then yes, 35%. Other 5%. So access to technology and I guess the internet, my experience is, with impoverished clients and the public, usually there's a friend or family member or employer who can make the technology available. I think there was a recent study that showed 97% of Canadians had access to internet. So certainly there's some room to improve there, but interesting poll results. Thank you everybody for sending in your responses. So pros and cons of virtual hearings. Jason, you want to take this one?
Sure. One of the pros would be that if you're able to do it from your own home or a familiar place, that's going to make you more relaxed, whether it be a conference, a motion, or a trial. There's an efficiency, no travel. You don't have to find parking spots. You don't have to fight traffic. You don't have to go to a place that's unfamiliar. Like I said earlier, you're staying at your home, it's familiar. So, there's an efficiency pro to this. Also less expensive for the client for that reason. You're not waiting for your case to be heard and paying your lawyer to sit there and travel there as well. Effectiveness. I know the poll has what it says, but I found them to be a lot more effective, especially conferences. Access to justice. I'll mention that as being a pro right now, but it's also potentially a con. Pro would be that, as I said earlier, less costly litigants. You have to look at it from both sides, and again, not paying your lawyer, but think about the client too, right? The client saves that money, but we're talking about their own life. They have to take a day off work to go to court, or take an hour off work to go to court. So now I just made more money instead of taking a vacation day, and that's not really a vacation, or a sick day, or whatever the case may be, and having problems with their employer. Plus, a lot of our clients, they're single parents. So if they have the kids that day, they're arranging childcare, perhaps, depending on time of year or how old the children are. So you don't have to worry about that. You've got an hour. So you got to find someone to watch a child for an hour, or your children for an hour, or watch your children for the whole day. So there's a lot of pros there to this, to being virtual.
Also, sorry, Jason, also victims of domestic violence, right? And for most people, there's an emotional toll to going to court. It's stressful. It's not something they're useful. And if you're a victim of domestic violence, you might have to face your abusive spouse in potentially a smallish courtroom or conference room. And that could be very overwhelming for a lot of people.
We're waiting in a hallway for 4 hours while they stare at you. Cons.
That's right.
Less in-person contact. I mean, that's one issue that we have, which is that the lightning in a bottle thing, as I said earlier, you get everybody in the same place at the same time, and you make some magic happening. So there's less discussion. You just zoom in, zoom out, and move on with your day, which is positive, but also a negative. Access to justice. We talked about technology. It's not all created equally. So this idea that a virtual court is beneficial doesn't mean the same thing to someone doesn't have technology, doesn't have dedicated Wi-Fi or whatever the case may be. This is usually the most vulnerable part of our society. So, are we protecting them if we do virtual hearings and they are most uncomfortable in that setting? The court is definitely thinking about this. They've more or less said that. That's where their mind is going. Evidence, as Rick said. If oral evidence is by video, then witnesses can communicate with anyone during a trial. There was a case where I read about Justice McGee did, and she had a real problem with one of the parties communicating with witnesses during the trial by phone, looking down at their phone the whole time, and witnesses looking at a party moving off screen to send messages on their phones. So there's that issue if you're doing it virtually. As well, PDFs. If we're doing everything with electronic documents, they can be manipulated. If it's all paper and it's there, fine, make us manipulate the PDF and print it. But at the end of the day, that when you're relying on a virtual document, how reliable is that document? So, I think we've had those challenges before, as I said, because you could just, manipulate a PDF and print it. But, that was something else Justice McGee pointed out in her trial. So I think, conclusion is, personally, I think we can manage a lot of the cons. Lawyers can have clients be at their office if technology is not a good thing. I had a client come to my office during COVID and we did a motion. We both had to wear masks. Yeah, that was unfortunate for me to wear a mask. The judge heard me and my client was there. So the client can come to the lawyer's office and do it virtually. If that may work, if the lawyer is comfortable with that. If they don't have a lawyer and they have to do it personally, well, legal aid may be available to give them dedicated Wi-Fi or other government places where that may be available to litigants. It's not perfect, but I guess you got to weigh these pros and cons. I mean, I hate to be a doomsayer, but I think the court has weighed these pros and cons already and already made the decision and feel like the cons that I've mentioned outweigh the pros, and they want some aspects in person. Whatever that motivation may be, whatever the explanation may be, we don't really know what's going on. But, that direction came down without speaking to the bar too much about it. And that's what we're stuck with right now, unless something will change.
Right. And there's certainly innovative ways to deal with the cons, right? We can turn the courthouses into justice hubs. They can still go and do the hearing in person if they don't have the technology. We can use public libraries. There's lots of ways to address these cons, but that's a great summary, Jason.
That's the hybrid method we talked about, and someone asked a question about that, and I don't know the answer to that question because I've not had any judge consider the hybrid method, even though it's been proposed to something. But that would be a hybrid. I'll show up in person, you show up virtually, and people, we do that before. We do it with people phoning them by telephone because they lived in another country, and judges didn't like it, but we did it.
It was commonplace, but.
Yeah.
We don't want to step back to 2020. We've made all these gains in efficiency and access to justice. Let's keep talking because I'm just going to go on a bit this more if I'm given any more.
I agree. But one last point, like technology, it took a pandemic to bring our court system into practically the century because, faxing documents. My kids have no idea what a fax machine is and they're not young. That's a dead technology. It's not going anywhere. Email is the way to go. And that's what it took. It took an email system, a pandemic to bring us into that element. So we've got to take leaps forward at times. So I don't know how virtual technology is any different than saying let's email instead.
We had 200 years of paper, right? Now, just think, you'd serve a document, then you'd commission an affidavit, then you'd serve the document, serve an affidavit. It's insane, the documents we're producing prior to the pandemic. But let's do a poll, because it's been a while. So what do you think the greatest risk of Zoom or remote court hearings is? And we've got a list of options. You've heard Jason talk about the pros and cons, so let's see what our audience thinks. Let's go to a question while we're giving everybody a moment. I'll throw this one at you, Rick. Is it mandatory to have your video on, or can you do audio only when you're doing one of these hearings remotely?
Well, you should have your video on. I guess if you're having video difficulty, that may be a reason to ask the judge permission to turn your camera off, but it is mandatory. The judge would expect to see at least to confirm that the person that they're saying that they're speaking with is the person that has identified themselves to the court. So,
Yeah, I think this is important, right? Is still a court hearing, and there's still a manner of civility and decorum expected whether or not you're in there in person or you're doing it remotely. So the video should be on. You're right. We should be able to identify, or if there's other people in the room influencing that particular party, we have a link to a video where a victim was testifying, and the prosecutor picked up that the defendant was actually in the room intimidating the victim during the trial. Sent over the police, arrested the defendant during the trial as he was intimidating the victim. So you need to see what's happening, and the video should be on in my assessment. Well, let's see what our audience thinks about the greatest risk. All right, less opportunity for settlement, 17%, intimidation, 13%, deep fakes and fraud, 23%, no hallway or face-to-face negotiations, 27%. That's sort of Jason's lightning in the bottle analogy, right? You got a chance to make a deal. Formality of the proceeding has a smaller impact. That's sort of the power of the sash and being in front of the courtroom, and the ceremony of the process is gone. So I think sort of evenly across the board here. Thank you everybody for sending in your answers. Somehow I get to speak to this one, plan for bumps in the road when you're having your remote hearing. So what are we looking at here? I think you just need to exercise some common sense and be prepared. So when I'm doing mine, I let my family know. So if they need to jump into the kitchen and make a sandwich or whatever, they can do so. And I let them know when it's over too. So then they can come and go about the house. I try to post a sign on the door. It seems the Amazon person comes whenever I'm online, rings the doorbell. And I exercise my dogs, because once the doorbell rings, they go crazy and the whole house explodes. And the judge is wondering what the hell's going on here, right? So exercise the dogs. It's also good to get some air. Put the sign on the door in case you're getting deliveries. Have a clean and tidy space. This is just common sense. Have a backup plan. So this is important. If you're on the road or traveling, when you're having your hearing, try to be in place where you're going to have a stable connection, and be mindful of your power sources, right? So if you're on a laptop, your battery may die, you may need to plug in. Have an alternate power source, a battery backup. Build in redundant systems, right? So maybe your computer crashes, so you're going to have to zoom in on your phone. Have some type of redundancy so you can access that hearing when it's time to go. Avoid public Wi-Fi. Final tip, do not update your Zoom software 2 minutes before the hearing's going to start, because it's going to be a 15-minute update and you're going to be late and stressed out. And same for your client, right? You may start and then your client comes in all flush and overwhelmed and nervous and anxious, and it's not going to be the same experience for the client if they're showing up 15 minutes late and the court's waiting for them. So those are just some basic tips for bumps in the road and to be mindful of. The tips and tricks, Jason, or sorry, I guess this is yours, Rick. I hope I didn't steal any of your ideas. What do you got for tips and tricks?
So, I mean, you covered a lot of them. Be early, dress professionally, sit up in your chair, make eye contact with the judge. And as Russ, you said before, treat this as if you're in person. It shouldn't be any different. The fact that you're looking at a computer or a camera, that you're going to act differently or be differently. So you want to look professional, act professionally, and be respectful to the court. You're still in court at that time. Speak loud, speak confidently, and address the court politely. So I think that would, and avoid multitasking. I've seen a couple of virtual attendances where the other side, and I think they were self-rep. They're doing more than one thing.
You've got the little side screen, or answering emails, or watching the YouTube video on the side.
So yeah, and so avoid the multitasking. But that would be my summary of.
There's cases, lawyers are at the pool in their bikini. One lawyer was in bed. A client was driving, during a hearing. Like, some of the examples we hear are pretty out there, right?
Yeah, that was early on, though. I think
Yeah.
after those videos went viral and everything, I think everybody kind of, that was a learning curve.
The cat
So
filter. I'm not a cat, Your Honor. I'm a lawyer.
for sure.
All right. Next one, case lines and Divorce Act changes. So we've literally spent hours on the Divorce Act and an hour talking about case line on different events, but let's just go through this because this is important to know if you're doing Zoom divorces, these two things. So I think I've got you up first, Jason. Is that right?
That's great. I'll talk about case lines first. I think the important thing to know about case lines, I love it. But it's not something that I find judges are always using. So my advice would be get prepared to use it. Some jurisdictions where I predominantly practice in Central East, they'll use it for case conferences. They don't use it for settlement. So, but be ready to use it. And I find that it's very helpful. Just be clear, it doesn't replace how we serve and file documents. So what I've been told by judges is do not upload something to CaseLines until you have served and filed it. It is not a replacement for that. You still have to serve documents as you normally would. You file them as you normally would, and then you upload to CaseLines. You do it before, you might get the ire of a judge because the other side said I never got it, or the judge said, this isn't a replacement for the record I get from the court. So you might have given something to CaseLines and I can read it, but when I got my court file, it wasn't in here, and I haven't read it for preparation for today. So be mindful of the fact that it doesn't replace that, but once you've done all what you're supposed to do and it's there, it's a method for sharing that information in a way where everyone can be, if done properly, you could literally draw everyone who's on CaseLines to a specific page and say, here's what document I want you to look at, or here's something I want you to read, Your Honor. And that's very powerful. Instead of saying, everyone, let's flip to tab 2, page 7, and everyone flips and it takes like 10 minutes for, you sure it's this page? It's not in my copy. It's all right there. It's all virtual. Right. So we skip through all of that. So for trials, for motions, extremely effective tool if done properly. Because there's even a notes section if you want to, where you can make your own little notes. So you've got it all on one screen and you're ready to go and you're confident and nothing can mess up because it's in the cloud. So a lot of people love it, and then you do a lot of work for it, and then in my experience, big waste of time because judges like, no, just share your screen with me on Zoom. I'm not going to use it. So I think get ready to use it. I think there's been a lot of money spent on this system with the court. It's going to be used eventually. Get familiar with it, but it's not a replacement for the continuing record, which is what you still have to prepare and work on.
One tip on the case lines, I remember when we talked last time, when you serve your documents, they'll send you an email saying it's been uploaded, right? And it's good to keep that email. So during the hearing, if the judge says, I don't have the documents, you can say, well, I've got my confirmation. It's administrative adventure in the technology, but you still did what you needed to do, and that'll insulate you from a cost order.
Agreed. So I mean, I think the best advice is do everything you were doing before and CaseLines and make sure you're behind this cover. But I'm saying I love it. I think some judges love it and use it, and it's fantastic when they have. And other times I've done extra work to prepare to make sure I can use it, and the judge is like, no, I don't have no access to CaseLines. I haven't looked at it. So they're not even using it sometimes. Okay.
Just hold your comments on the Divorce Act for a second. Let's run our final poll, and then I'm going to get right back to you, Jason. So our final poll, in your experience, what percentage of cases settle at the case conference stage? So take a minute or so, Jason, and wrap up on the Divorce Act.
Well, I think
if you have a minute.
Well, I can do it in a minute.
Okay.
Major changes. There was a win-lose idea of custody and access. They changed the terminology in there. That's no longer custody. It's decision-making responsibility, no longer access. It's called parenting time. I agree with those terms, in my opinion. I think that there was a win-lose idea, and people would feel that custody was a 4-letter word, even though it wasn't. Well, sole custody was. But in any event, another major change is ADR first, an idea that figure things out. Don't come right into court. We're not here to solve all your problems. Find another way to resolve them, probably more healthy, more therapeutic way than a courtroom. Courtroom is very sterile. You're not going to get a judge thinking about everyone in the equation. Do you want me to keep going, or do you want to talk about your poll results there, Russ.
Okay, no, that's great. But we do have a multi-part series on Divorce Act changes if you want to learn more on recording, and a 6-part series on our podcast. So looks like more cases than less do not settle at the case conference stage, which I think is consistent with my experience. So let's just flip ahead a couple slides and talk about some upcoming things I want to mention, and then we're going to bring this train into the station and do some Q&A. So after this one, we have we've got a petition that over 1,200 lawyers have signed, saying that all hearings should be presumptively remote. And so I think there's a significant part of the family bar that do not agree with these presumptions. Will be a link to the petition in the show notes if you want to learn more. We've also had a live press conference talking about the petition results and some of the objections we've had. That recording is going to be made available in the show notes. We're going to be conducting a town hall on July 27th to talk about this particular issue, the presumptions of returning to person. Just want to get those out there. You'll see that more information on the show notes. Now we're going to bring Shannon back in to bring this train into the station. Welcome back, Shannon.
Thank you. So just before we get into Q&A, I just want to remind everyone that there will be a survey that pops up at the end of the virtual event that will be asking for your feedback. We welcome and appreciate any feedback you have. It really gives us insights into our audience and how we can continue to grow. So as a sign of our appreciation for those who do provide their feedback, we will be provide their feedback and offer a suggestion. We will be providing a complimentary e-copy of Russell's new book, Zoom Divorce. So with that said, we have just a couple more minutes that we'd like to try and fit in a couple more questions from the audience for Q&A. So first question I have here is, I know our speakers have already touched on attire a little bit, but if you have any other comments to answer this question, it says, can you touch on what to wear and how to conduct yourself during court?
Rick?
What to wear? The general rule of thumb is, well, if you're counsel, you're expected to be robed on certain occasions for motions and trials. Otherwise, in business attire. And the same would apply for self-represented parties, to be in business attire.
Thank you. Another audience question we have here is, how do you sign documents when both parties are not in the room together, including if both parties are in different countries?
Jason, what do you think? DocuSign?
Yeah, there's DocuSign, other technology where you can sign things virtually. That's allowed. Only warning if you're a professional is that make sure that you know that the person's, you're not technically there unless you do a video call with them, seeing them sign the document. So if you're worried about that type of liability, and maybe you should be doing it that way. So have a virtual call, let them see, you see them sign the document, then you can commission. You see them sign an agreement, then you can say I witnessed their signature, and that's perfectly acceptable. There's clauses you can add to minutes or consents or agreements that say we're allowed to do this virtually, allowed to do in different counterparts. And we had that kind of thing before, because when people would not just sign the original, if you wanted to get settlement funds released quickly, for example. But now we can do it electronically and add that clause, and so that's something we can do to streamline that problem.
Great, thank you. That looks like that's all the time we have today for the Q&A. We just want to be mindful of everyone's time, but also want to thank everyone for joining us and sending in those questions, for all of your participation with the polls. We really appreciate it. I just want to thank our panel once again for sharing their insights. We hope you all have found the presentation helpful. Just another note, just to remind everyone that I will be sending a follow-up email, as Russ mentioned, with links to some of the resources mentioned throughout today, so you can take a deeper dive into today's subject on your own time. And if you do have any questions about our virtual event series or any comments for our team, you can reach out to me at shannon@russellalexander.com. And just a note for anyone that's new that's joining us, we do host these events virtually bi-weekly on Wednesdays at 12 p.m. And our next topic will be on divorce and business valuations advanced topics. It's a second part to a virtual event that we hosted a couple months ago. So that will be on July 13th at 12 p.m. And as registration is now open for that, and as Russell mentioned, we will have the town hall with the committee that will be at the end of the month, and registration will be open for that soon. But we will be including a full list of our upcoming webinars in that email as well. So we just want to thank everyone again, and we hope you all have a wonderful day.
Thank you, Jason. Thank you for your time today, Rick. Those were really excellent insights.
Thank you very much, Russ. Thank you.
Thank you.
Shannon, great job hosting as always.
Thank you. It's a pleasure. Have a great day, everyone.
I'm looking forward to your playlist for the next live event. Taking
audience requests. Send me your requests, everyone.
You can find Shannon online at DJ Shannorama.
Need to work on my website.
Great. Have a great afternoon, everyone.
Bye, everyone.